Good morning, everybody. My name's Kate Wyke and I'm Wales Manager for Contact. I'm really pleased to see everybody today. Hope you're feeling good, or at least you're feeling warm and you're in a good place today. We're the charity for families of children with disabilities and additional needs of any kind. And we support families with children from the age of birth to 25. What's quite unique about Contact is we support families of children with and without a diagnosis. We don't turn away anybody, and we have lots of ways that we support you, such as today, like webinars, etc. But we also have a brilliant website, which we put in the chat. And we also have free events, helplines, guides, information. For anybody who's joining from Wales today, at 12 o'clock today, we'll also do a drop-in. So if anybody would like to join that drop-in, I've popped it in an email to you with the link, but you can speak to me and some other parents at 12 o'clock if you want to. But today we're here to run the Wills and Trusts webinar. As I said, I'm Kate Wyke, Wales Manager. I'd like to introduce Dylan, who is our Information and Networking Coordinator. Dylan, if you want to say hello or give a wave.
Hi everyone. I have changed my name because I realised it just said Dylan. But if anybody needs to ask any questions in the chat, you can just privately message on there as well if you don't want to put it public to everybody.
Thanks, Dylan. And the webinar should run for an hour. We may have some time at the end to answer questions. But please feel free to add your questions in the chat. If that's a difficulty for you, you can always contact me after the session, and we can share with Stuart from Irwin and Mitchell any questions that you might have. So I'd like to now introduce today our guest speakers from Irwin and Mitchell. So we have Stuart Stretton-Hill, who's the Senior Associate Solicitor. And also you'll see Nicole, and Nicole Quinn is the Business Development Executive. So if I can now hand over to Stuart to start the webinar. Thanks, everybody.
Thank you very much, Kate. I'm hoping once Kate works her magic, you'll be able to see my slides on screen. I can't tell when they've switched over, so I'll leave it to you, Kate, to make sure they have. So lovely, I'm getting a thumbs up. So good morning, everyone. Really nice to see so many people on this webinar. It's always rather daunting when so many people want to hear me speak, because I can go on for hours about wills. But I know I've only got an hour today, so I will try and rattle through it as quickly as possible. And excuse me sounding a little bit croaky this morning. I am fending off a cold. It's not the dreaded COVID, thankfully, but you know what children like, bringing stuff back from school with them. So who am I? I'm Stuart Stretton-Hill. I'm a Senior Associate with Irwin Mitchell. I've been doing private client law for longer than I care to remember, about 13, 14 years now. And what does private client law mean? Well, basically I specialise in helping families plan and protect assets for beneficiaries who might lack capacity, might have difficulty managing their own financial affairs in the future. So we do that via all sorts of methods, by helping people draft their wills and put trusts in their wills, helping people put in place powers of attorney or deputyships. Basically what today is about is talking around that subject and giving you some information about the sort of things you should be thinking about, explaining a bit about powers of attorney, a little bit about deputyships, but mostly I'll be diving into how you can put a trust in your will to protect your children in the future. And I'm also going to be talking about what happens when your child reaches 18, if they are unable to manage their financial affairs. What can you do to help them in the future? So I hope this will last about an hour. I might go on. Apologies if I do. I'm sure Kate will cut me off if I'm going on for far too long. As Kate mentioned, you're very welcome to submit questions during the course of this. Please pop it in the chat if you've got a question to go there. I'll aim to answer questions as we go along. Hopefully we'll have some time at the end. But as Kate said, if we don't manage to get onto them, then we can always respond by email afterwards. I had a question on a webinar I gave previously about which country the advice I'm going to be providing relates to. It's England and Wales, basically, so should be relevant for everyone on this call. So I was going to start with an overview of deputyship, talk a bit about using a trust versus using deputyship, the importance of wills. Wills are really important things to put in place, and I'm not just saying that as a lawyer. Hopefully you'll see from the outcome of this webinar that there are so many reasons why you should be making sure you have a will and that it is kept up to date. And I'm going to be rounding off with the role of trusts in a will. And don't worry if you've no idea what trusts are. I'm going to be going through and explaining how they work. They're quite technical, but I'll do it at quite a high level. So you're welcome to ask questions of more detail in the chat. So what is deputyship to start with? Well, when someone reaches 18, they are essentially an adult, and they are entitled to take decisions for themselves in relation to their finances, in relation to their health and welfare. But what if they don't have legal capacity? What if they don't have mental capacity? Well, what does mental capacity mean to start with? And as far as the law goes, the test is decision and time specific. And what that means is someone might have mental capacity to take one decision, say paying a gas bill, but they may not have capacity to take another decision, say selling a house. So that's what it means by being decision specific. Time specific means someone might be temporarily incapable. For example, you've been out on a Friday night, you've got completely slammed, you're not going to be capable of making a will at that point in time. But after you've got over the hangover the next day, yes, you will have capacity to make a will. So it's time and decision specific. And that's what makes it a little bit tricky about deciding whether someone is or is not able to take decisions for themselves. But if someone lacks capacity to take financial decisions, then no one can take decisions for them unless you've got a power of attorney in place, a lasting power of attorney in place, or a deputyship. A lasting power of attorney is basically a document that the individual signs themselves saying, I would like mum or dad or whoever to deal with my finances. You can only make a power of attorney if you're over 18, and you can only make it if you have the mental capacity to do so. And so that means that you can understand what you're doing, what authority you're granting by making that power of attorney. That might involve getting a medical expert involved in the case. And quite often I see clients and I think, I'm not quite sure whether you've got capacity. I'm pretty good at judging myself, but I'm not as expert as many doctors. So we will get a specialty consultant involved to reach that decision as to whether someone's got capacity. If they don't have capacity to make a power of attorney, you're looking at a deputyship. And a deputy is essentially a court-appointed attorney. And anyone, absolutely anyone, can apply to be someone else's deputy, which sounds a little bit daunting, but you need to show why it's appropriate for you to be that person's deputy. And that may well be because you're the parent or because you're their carer. But when there's no one else who's able or willing to do it, the local authority can apply to be a deputy, which can be a little bit daunting. I mean, as I get older, I think, if I lack capacity in the future, I don't like the idea of the local authority managing my finances for me. So it's the same, as I say, for people over 18. If there's no one else willing or able to do it, then a local authority may well apply. The authority of a deputy is more restricted than an attorney. The deputy can only do what is on the order granted by the court. An attorney has wider authority. It's not unlimited, but it is wider. And a deputy also has to buy an insurance bond, so that basically they've got to buy a bond to protect the individual from mistakes that the deputy might make. We all make mistakes, and that's what the insurance bond is in place to do. It might involve a court hearing applying to be a deputy. More often than not, it doesn't. If no one's objecting to you applying, then it's usually fine, and the court will rubber stamp it. The papers go off, the court looks at them and grants the order. But if someone objects to your appointment, and you do need to notify various people when you make the application, if someone objects, then it might involve a court hearing, and the court decides who is the most appropriate person to be the deputy in that case. But it's a long process. It's commonly more than 6 months. I put 6 months there. These slides were prepared a while ago. There's been a big backlog in the courts due to COVID and all sorts of things. So you should be budgeting nine months at least for a deputyship order to come through. So think ahead is really my advice there. I'll just touch on health and welfare. So I've been talking about getting a financial deputyship there, the ability for you to be able to manage the individual's finances. And a question has popped up, can you be an appointee? Yes, absolutely. You can be an appointee, which means managing someone's right to benefits. So contacting the DWP and getting the person's benefits paid. That is something you can do, absolutely, and that doesn't require a court hearing. And where the child does not have many assets of their own, or any assets of their own, they might have a small amount in a bank account, but basically nothing else, you may well not need a deputyship. So you can simply be an appointee, manage that individual's benefits. A deputyship is only really required where the individual has substantial other assets of their own. So I was going to touch on health and welfare. So again, once someone's over 18, they have the right to take health decisions for themselves. If they lack that capacity, then those decisions will be taken by the local authority in the case of care, or by a doctor in the case of medical treatment. Family should be consulted, but the decision-making ability is with the local authority or the doctor, unless the child has done a health and welfare power of attorney, giving that ability to take those decisions to someone else. In terms of a deputyship, it's very rare for the court to grant a health and welfare deputyship. And that's because the court says, well, there's already processes in place for local authorities and doctors and so forth to take decisions in the child's best interests. Quick question popped up there. Do you need to notify people you're applying for power of attorney? No, you don't. You can, but you don't have to. But bear in mind, it's the individual themselves who's making the power of attorney. So if they're happy with what they're doing, they don't need to notify anyone. When should you apply? Well, bear in mind the court can't make a deputyship order until the individuals are over 18. You can start the process before that, certainly, but more often than not, people wait until the individual's turned 18 or until it's an appropriate time to do it. So when's a deputy needed? I've sort of touched on this already, but what the deputy will be doing is managing bank accounts, paying bills, selling property, signing contracts and leases, potentially, as say, if you have a health and welfare deputy, managing care arrangements. And so you don't really need a deputyship unless the individual needs to do any of those things, managing accounts, etc. Deputies and attorneys are supervised by the Office of the Public Guardian. They're sort of the deputyship police. So if anyone has a concern about what a deputy or attorney is doing, they can report those concerns to the OPG, who will investigate. They might call for accounts. They might send a visitor around. The OPG can send someone to visit an individual to see what they're doing and interview them. And if the OPG don't like what the deputy's doing or what the attorney's doing, they can apply to the Court of Protection to remove that individual and replace them with someone else. So a deputy does not have free rein. They can't do absolutely everything. And a classic example is a deputy cannot make gifts on behalf of the individual. May not be relevant, but certainly in some cases I get involved with, certainly with older clients, they want to do tax planning, they want to give assets away, they want to make a will, that sort of thing. Then you need to go to the court for permission to do certain things. Question popped up about the insurance bond. The court provides information on where to get the insurance bond from. And also a question popped up about bank accounts, but it just disappeared off my screen there. No, an 18-year-old does not legally need their own bank account. As I say, an appointee can manage it. I'll come on to wills in a moment. Another question popped up there. So, speaking of which, wills versus deputyships, or will trusts versus deputyships. So let's say you have a very straightforward will. You leave everything to your child. At age 18, they are the person who is supposed to manage that money. If they cannot do so, then you are looking at a power of attorney or you're looking at a deputyship. And I say the deputyship process is very involved. I didn't mention, but deputies have to do annual accounts. They have to report to the court every year to say what they've been doing. So it's quite involved, quite tedious to some extent. If instead you don't leave assets outright to your children under your will, You put them into a will trust, and I'll talk about how you can structure those trusts in a minute, but you leave the assets to a will trust. Your child does not inherit those assets automatically. They are looked after by the trustees, who are the people you appoint in your will. The trustees don't need to report to the court. They don't need to make annual statements. They don't need to go off to the OPG. It's very, very flexible, and provided you pick the right people, and the clue is in the name, trustees, people you trust to manage your finances for your child, then it's a very flexible way of dealing with things. It keeps assets out of your child's hands, so that if they are, if they lack capacity, then they don't have to manage them themselves. If they're vulnerable, so they're easily influenced, the trustees can keep an eye on that money and keep hold of it, so the child doesn't give it away. They're a very, very useful tool, and I certainly would encourage them putting a will trust in your will if you have a child who is vulnerable or potentially lacks capacity. Sorry, excuse me. So, talking about wills now, slightly more generally, as I'll come on to will trusts. I get so many people who say, you know, it's all right, we're married, we have one child, everything's going to my spouse and then down to my children. That's fine. That's what happens even without a will, and that's what's called intestacy. If you don't have a will, you're what's called intestate. Well, for reasons I've just touched on, as I say, it may not be a good idea for the child to get assets outright under a will trust, under the intestacy, then a will is vital there. It gives very clear statement of who has the authority to deal with your estate. It's certainty. You know exactly what's going where. It can be flexible. Pop in a will trust. You can do. It makes it very, very flexible to do planning in the future. So I'm going to come on to those individual things in a little bit more detail. So, looking at authority. In your will, you will name executors. They are the people who have the right from the date of death to deal with your estate. So commonly, the first thing they'll be doing is arranging the funeral. So it's always a good idea to put in your will what your funeral wishes are, because that's obviously going to be the most emotional thing to deal with. And so often I get people coming to me saying, I don't know whether mum or dad want to be cremated. I don't know where they wanted to be buried. And just putting a simple line there, I wish to be cremated, really takes quite a lot of burden off the family. From the date of death, executors can distribute personal belongings. Personal belongings are a bone of contention. I have had so many cases where siblings and children argue over, you know, a watch, or in one case, a pair of bronze dogs that were worth 12 quid. You know, there was a huge argument about this, lasted for hours. So I'd say, you know, make it quite clear if there are specific family heirlooms, certain items that have sentimental value, make it clear in your will who those are going to go to. Have a talk with the children beforehand. Have a talk with relatives beforehand about who might want what. I know it sounds horrible. I know it's not the conversation for the Christmas dinner table, but it's much easier to have those conversations before you die, frankly. Executors can correspond with the bank straight away. They can start closing the bank accounts, or I say closing, freezing the bank accounts from the date of death. And that's important because if someone dies, potentially, you know, fraudsters can try and get access to those accounts. If you register the death straight away with the bank, then you know that account is frozen. No one can access it without getting the grant of probate. And the grant of probate is the legal document that an executor will need to apply for, to show to the bank, to show to the land registry or any financial institution where the deceased had assets, saying, look, here's the court order, here's the grant of probate, saying that I am the right person to deal with the estate. Really important under your will, you can appoint guardians for children who are under 18. Very, very important to do that. One thing I'd say to people, if you are appointing guardians, leave a letter of wishes alongside your will that says, these are my thoughts, these are my wishes about how I would like my child raised in the future. This is where I'd like them to go to school. These are the friends I'd like them to carry on seeing. This is where I'd like them to live. Very, very valuable, so that you know your child is getting the upbringing you want. Certainty. Certainty is a really important thing about a will. It helps to avoid disputes in the future. Sitting down, talking to your family about what you're doing with your will, particularly if you're doing something slightly unusual, benefiting one child more than another, which is fine. You know, I often have people saying to me, can I give my daughter more than my son? Well, yeah, it's your choice. But explain why. If one of the children has a more significant need, then yeah, it may well be appropriate to give them more money. Equally, if that child is on benefits, you think, oh well, no, I don't want their benefits to be affected, give them less, or put their share in a will trust, but give the other child their assets outright. So have that conversation with the children while you're alive, so there's no surprises. It helps to avoid disputes. You know exactly who's going to be dealing with your estate, you know what your funeral wishes are, and you know who's looking after your minor children. If you're intestate, if you don't have a will, it's up for grabs. Who's going to apply for guardianship? Okay, the intestacy rules do say who gets what, but you don't necessarily know who's going to deal with the estate. Technically, it's the person who's first in line. So if there's a surviving spouse, they will be the person dealing with the estate. If it's a child who's under 18, okay, who's going to be dealing with the estate on their behalf? You don't necessarily know. So make a will to ensure you appoint the right executors. And finally, flexibility. People have this image of wills that they're sort of illuminated by monks with scrolls and quills, and there you are, that is it, that is your will, that is there for the rest of your life. It says exactly who gets what and when. You can be really flexible in your will. You can use this trust structure. I've been talking about this already, and so I'm going to dive into a lot more detail in due course. But instead of saying, yes, my son gets £20,000, my daughter gets £10,000, whatever it might be, you say, right, here's a trust, what we call a discretionary trust, in which you essentially say, dear executors, here is my estate. You decide how it's split between the beneficiaries. And here is a letter that I've left you saying what I would like you to do. And that letter can say whatever you want it to say, and it doesn't have to be shown to the beneficiaries. It's a private document between you and your executors that might say, yes, my son has special needs. I would like you to make sure his benefits are protected. Please don't give him any capital. Please keep it held in the trust. Give him an income, buy assets for him and loan them to him, that sort of thing, so that his benefits are not his benefits are protected. And then on the child's death, the trust will carry on going, and those executors can decide where those assets should go after the child's death. And so I'm going to dig a little bit more into that in due course. But it's really helpful because, as the beneficiary is not getting the assets outright under the will, if they get divorced, or they have a dubious boyfriend or girlfriend who's trying to get their hands on the money, or they lack capacity, it's the trustees who control the assets. It's not the individual themselves. So it really helps protect assets for that child in the long run and for future generations. It's also possible to use your will to reduce inheritance tax. I'm not going to major on inheritance tax today. It's a really long-winded and complicated subject, but just broadly speaking, you can leave, anything you leave to a spouse or charity is tax-free. There's no inheritance tax on leaving assets to a spouse or charity. Anyone else, children included, there is tax, and the tax is due on the value of your estate over £325,000. If you're a married couple and you haven't used this nil rate allowance, this £325,000 on the first death, so let's say everything's left from one spouse to another, the first to die has not used their £325,000, that means you can leave £650,000 to the children tax-free. In addition, if you own a property, a residential property, that you leave to a child or a direct descendant, so that could be grandchildren, stepchildren, and so on, then you get an additional £175,000 per individual. So again, spouses can double up that 175,000. So technically, you can leave £1 million tax-free to your children in the future. But you've got to be careful to make sure you structure things properly. And I've got a case study later which will show, which will talk in more detail about that. Just leaving that quick question there, can an adult child have money in a trust? Yes, you can leave money in trust for absolutely anyone, whatever their age. Oh, I've already covered that. Sorry, I didn't switch the slide over, but there we go. Yes, so as I say, inheritance tax, 40% on the value that exceeds the nil rate bands. Up to £1 million essentially can be left tax-free if you structure your will correctly. So that's the advantages of wills. What happens if you don't have a will? Well, really the warning stories here: lack of authority, uncertainty, no flexibility, all essentially the opposites of everything I've already been talking about. So where you have a will, the executors have authority from the date of death. Where you don't have a will, the individual dealing with your estate will need to apply for the grant of administration. That can take a few months. And while they're doing stuff, if they're trying to do stuff with the estate, they are personally liable.
I think Stuart's just been... Oops. Can everybody hear me? Just give me a quick wave. It's Kate. Yeah, I think Stuart's just come out of the session by accident. Not to worry at all. He'll come back in and we'll get the webinar up and running as soon as possible.
He's still in on my screen here. It says he's muted.
Okay, let's just unmute him. Because his slide's gone off, hasn't it? This is what happens with digital. It's not a problem. Hi, Stuart. We can still see you. We're not sure if you're in there, but if you can unmute and restart your video, please. It might be worth you coming out and coming back into the session. So just a little reminder to everybody that the session is being recorded. So therefore, if you do not want to be on video, please switch your camera off. Okay, Stuart's coming back in now.
Sorry about that, everyone. Hopefully you can hear me again.
Yeah, we just need you to start video and you may need to reshare.
No problem, just doing it. The wonders of
no
technology.
Problem at all. Yeah.
Hopefully you got me back there. Hopefully you got me back.
Yeah.
So, sorry about that. I'll be having a word with Virgin Media later. So yes, covering off again, lack of authority. What happens if you don't have a will? Uncertainty. So your estate is then governed by statute that says who gets what in your estate, rather than your will saying who gets what. And it may not go the way you want it to. There is this assumption that a spouse will receive everything in your estate after you die if you don't have a will. Not necessarily. You've got to be very careful about how things are owned, what assets you've got, and whether there might be any other entitlements. So a really important thing as well is who's going to be looking after your children. So I touched on that, the idea of appointing guardians. You don't necessarily know who is going to apply to look after your children after you die if you don't have a will. And no flexibility. Well, if you under the intestacy rules, a family member receives assets outright, then if they're bankrupt or they're going through a divorce, those assets will be lost in the bankruptcy or the divorce. If you're leaving it to a child, or if the intestacy rules leave assets to a child who's on state benefits, yep, the child will lose those state benefits. And minor children get the money at age 18 under the intestacy rules. I mean, my kids are quite young, but I dread to think about what they're going to be like at 18. There's no way I want them to inherit my assets when they get to that age. And there might be unnecessary inheritance tax if you've got unequal estates. Let's say husband's got only £20,000, something like that, whereas wife's got 400,000. If the wife dies first and the assets pass accidentally directly down to the children, there will be inheritance tax there. You'll be losing out on claiming the nil rate band from the spouse. So structure the will, get a will in place, and avoid the uncertainty and the rigidity of the intestacy rules. Now, I said I would talk in more detail about trusts, and that's what I'm going to do now. Forgive me, I'm just setting up the chat settings because I seem to be only able to see messages to Kate at the minute. No, I can still only see messages to Kate. Sorry about that. I'll carry on with the presentation. Please do keep putting your questions in the chat, and hopefully I'll be able to get to them at the end. So I've talked about a trust. What is it? Really, what is a trust at the end of the day? And it's what we call a sort of separation of the legal and beneficial ownership. And the simplest thing to think about is a bank account that you have for a child under the age of 18. You are the legal owner of that bank account. It's your name on the account. You are the person who can pay money out of it. You can close it. You can transfer it to another account. You are the trustee of that account. The beneficial ownership, though, the person who's actually got the right to that money is your child. So if as trustee of that account, you took money out and gave it to yourself, you are in breach of trust because you're taking the beneficial ownership away from your child. It actually belongs to them. And at age 18, they can turn around as the beneficial owner and say to you, dear trustee, dear legal owner of that account, sign it over to me now. I want to have control of it, please. And that is the most basic type of trust you can get. And I say trusts are a much easier concept to understand if you just separate out the idea of whose name is on the legal title compared to who does the asset actually belong to underneath. And you see this at the land registry a lot. So whose name is on the land registry deeds as the trustee, but who owns it, the property underneath, there might be a declaration of trust or something underneath that says actually the property is held for someone else. So just keep that concept in mind as we talk through this. So 3 types of trust interests. You can only ever have 3 types of trust interests, but you might hear about all sorts of different trusts. You might hear about bare trust, life interest, discretionary, asset protection trusts, spousal bypass trusts, pension trusts, all these sorts of things. There are so many names out there for all sorts of different trusts. But there's only 3 types of interest you can have under a trust. And those different names are sort of combinations of the different interests. So bare trust is exactly what I was talking about just now, the nominee bank account for a child. Legal owner is one person, beneficial owner is the other person. That beneficial owner has the absolute right to those assets. They belong to them in terms of capital, they belong to them in terms of income. A life interest, again, you have the trustee managing that trust, but the beneficiary doesn't have the right to everything. Instead, one beneficiary, the life tenant, has the right to income from that trust and income only. Another beneficiary has the right to the capital when the life tenant dies, or when I say dies, actually when the interest of the life tenant comes to an end. And it can a life tenant's interest can come to an end through all sorts of things, and usually it be specified in the trust document, in the will itself. So you might say, I leave my house to my wife for life. She can live in there for the rest of her life or until she gets remarried, at which point her life interest comes to an end, and then the capital value of that house goes directly down to the remainder beneficiaries, in this case probably the children. And you often see that with step families involved, where you want to make sure that your new spouse is well looked after, but you want to make sure actually the assets come back down to your own children, and a life interest is a really good way of dealing with that. And a discretionary trust is the most flexible. It's that one I talked about earlier under the will, where basically the beneficiaries have no entitlement whatsoever. So you give a huge list of beneficiaries, but none of them can turn around to the trustees and say, hand over the money, hand over the income. They've got no right whatsoever. It's entirely up to the trustees to decide what, if anything, to give to those individuals. So it's really, really flexible. But the thing is, you've really got to trust those trustees to do the right thing. You would usually leave a letter of wishes with the discretionary trust saying, look, this is why I've set this trust up like this, and this is what I would like you to do. This I would like you to give my daughter some money from it. I'd like you to give my son an income. I'd like my wife to live in the house, whatever it might be, but really, really flexible. The letter of wishes is not binding on the trustees. That's the most important thing to realise. Trustees can depart from a letter of wishes and do something totally different, and the beneficiaries don't really have any right to turn around and say, hang on a sec, hand that money over. So say, if you have a discretionary trust in your will, make sure that you pick the right people to manage it. So what are the advantages? I mean, trusts are a little bit complicated in their way to run. You need to make sure you've got the right trustees. You need to make sure they're doing their tax reporting each year. You need to make sure they are keeping an eye on the trust assets and managing them properly. But the advantages are that the beneficiaries under a life interest or a discretionary trust have no right to the capital value whatsoever. And that means if the beneficiary of that trust is mentally incapable, you don't need a deputyship or attorneyship to manage the assets. The trustees look after them. If you've got a beneficiary who likes spending money on eBay or on Amazon, and I glance over to the parcels that arrive at the door every day for my wife, the trustees are looking after that money. It's not the individual themselves. Yes, the trustees could give them some money. You know, if the beneficiary says, "Oh, I've seen a really good car that I'd really like," the trustees say, "Okay, actually, yeah, that makes sense. It's sensible for them to have a car because they need to get to work, whatever it might be. yes, we will give you money to buy that. Or they might say, we will buy the car and let you use it. But it means that the beneficiary can't just spend that money on anything they want. The trustees are looking after them. Third party influence, I touched on that before. The idea, if you've got a dodgy girlfriend or boyfriend of the beneficiary, the trustees can keep an eye on things, make sure expensive gifts aren't being purchased out of the trust fund. The trustees can eke the money out. But if they see it's being misspent, they can say, no, we're not going to give you any more. You keep spending the money on this gold digger. We're not going to give you any more money from the trust. Preservation of assets are a really important part of trusts. This idea that if you have a beneficiary who is in care, in a care home, or is in receipt of state benefits, then the trustees can say, we're not going to give you the money from the trust, which means that the individual shouldn't lose their entitlement to state benefits. Their assets don't go over that capital limit. But they could, say, give them an income to help pay for the stuff. They could buy assets and loan them. A classic example is an individual's in a care home, a local authority care home, something like that. The level of care they're getting is okay, but not brilliant. The trusts can use the money to top up and buy better care. And I touched on this as well, bankruptcy and divorce. So if a beneficiary is getting divorced or they are bankrupt, the money does not automatically belong to them. It means the trustees can wait. They can sit back and say, right, once the divorce is over, once the bankruptcy is over, then we will hand the money to you. And I say it's really, really flexible as well. So you're deciding who gets what and when, and there's no court deputy required. Now, a few questions have popped up. Thank you, Kate. I think you managed to put me back in the main screen there. So what if trustees die? That's okay. I was going to say that's okay. That's not a nice way of putting it. But trustees can appoint new trustees. So if one dies, the surviving trustee can appoint someone else to act alongside them. You need a minimum of 2 trustees on all trusts. As I say, the surviving trustee can appoint someone else. If that surviving trustee dies, the last trustee dies, the executors of the trustee's estate will apply, can appoint a new trustee. Question, can you transfer properties to children before death to avoid huge inheritance tax? No, not a good idea. Well, yes, you can, but not a good idea. If you transfer an asset outright to a child, so you don't put it in trust, you basically give it to them outright, you lose your rights in relation to that property. If the child gets divorced or decides they want to sell that house, they can. You can't object to it. Equally, it won't work for inheritance tax purposes. If you give an asset away but carry on enjoying it, the revenue will say, well, it's still your asset, treat you as still owning it. So inheritance tax planning by giving assets away but retaining a benefit is not a good idea. There are things you can do, which are a bit too technical for today, but there are certain options. I'm going to crack on. There are a few more questions. I'll try and get to those at the end, but I will crack on with the presentation. Excuse me. Disadvantages of trust. I've talked about all the fantastic, fun, useful things about trust, but there are some disadvantages, of course. Nothing in life is free. Administration. Trustees need to do their job properly. They need to be having meetings each year. They need to be reviewing, making sure the trust is still fit for its purpose. If they think it's not, if they think actually, the child's doing well for themselves, we don't really need this protection in place, they can wind up the trust, give the assets to the child. On the other hand, if they think, well, we're giving the child an income, but that he's frittering it away, maybe we'll turn that income tap off and keep the income back in the trust. But they need to be having those meetings, making sure they are reviewing the terms of the trust and complying with their duties. Compliance, there's lots of compliance. Trustees must complete a tax return every year. They must have a trustee investment statement that says, this is how we are investing, this is how we are looking after the money in the trust. Potentially, they might be in a position of conflict. If you have a trustee who's also a beneficiary, which is fine, you can do that. There's nothing legally preventing you from doing that. But if you have a trustee who's a beneficiary, they've got to be thinking carefully about, well, actually, should I be giving myself this money? I've got a co-trustee. I've got to talk to them about it. But there is the possibility of ending up in a conflict there. Also, be very aware that if trustees are negligent, if they are fraudulent, if they run off with the money, or if they make a mistake, they are potentially personally liable for losses to the trust fund out of their own pocket. And there's no insurance for that. So trustees need to make sure very, very carefully that they agree with what they're doing, that they understand, and that what they're doing is for the best interest of the beneficiaries. There's also an associated cost as well. I mean, you don't have to involve lawyers, you don't have to involve accountants to deal with the tax returns and legal implications, but to make sure the trust is run properly, you probably will want to, at least in the first few years, get a professional involved to make sure you're complying with all the trust duties. So there's often a cost involved there. A couple of questions have popped up there. Can a trustee be an older sibling? Yes. Must trustees live in the UK? No, but beware, if all the trustees are outside the UK, you might be suffering foreign tax complications there. So it might be considered an offshore trust. And that has all sorts of issues with the revenue. What if trustees disagree? Yeah, you got a problem. Trustees must act unanimously. So if trustees agree, nothing can happen. So one trustee says, yes, I think we should buy Kim a house, let's say that. And the other trustee says, no, I don't disagree with that. Nothing can happen. That house cannot be bought. In worst case scenarios, yeah, the trustees have to trot off to the court to get a decision as to what should be done. Better thing to do if you're worried about trustees disagreeing, either have a third party independent trustee there who can act as sort of a voice of reason. They still would have to agree, but at least they can sort of mediate, or appoint a completely independent trustee to take decisions in respect to the trust. Tax implications of trusts, that is another disadvantage. So the starting point is trusts pay income tax at 45%. Trusts only have half the annual allowance for capital gains tax purposes, and they pay the higher rate of capital gains tax, either 20 or 28%. And this is because government don't like trusts, frankly, to be at the end of the day. They think they're a way of sheltering assets and avoiding paying care fees, this, that, and the other, which they are. So that's why the government taxes trusts quite heavily. But if the beneficiary is a vulnerable beneficiary or a disabled beneficiary, then you can make an election that the trust assets or the trust income and capital is taxed as that beneficiary's. So it would be as if that beneficiary owned the assets outright. They pay the tax at their normal rate, but they don't own the assets. So it's a useful way of saying, right, from a tax perspective, it's no different as if we'd given the assets outright to the individual, but they don't own them. So we have all those asset protection advantages I talked about earlier. Similarly, with inheritance tax, we normally only think about inheritance tax hitting on death, but with trusts, they hit every 10 years and when assets leave the trust. So if the value of the trust is more than £325,000, you're suffering a 6% charge when assets leave the trust, not when income leaves the trust, but when capital leaves the trust. And every 10 years, there's an anniversary charge of 6% on the value that exceeds £325,000. But you can make a disabled person's trust for a disabled person, or if it's a life interest trust you're leaving under your will, it's as if the beneficiary had received the assets outright for tax purposes. Do you have to have more than one trustee? So yeah, you do need more than one trustee for life interest or discretionary trusts. Bare trusts, that simple arrangement, you can have just one trustee there. Major advice about trusts: do it properly. Make sure that when you draft the trust under the will, under the trust document, there are the right powers there. It's exercised correctly. The trustees know what their duties are. They know how to deal with things properly. It's documented. Documentation is so important when it comes to a trust. Yes, you may say, oh, we'll just give one of the beneficiaries £20,000. We'll just do it. Document that you have. Put a deed in place that says, yep, this money has left the trust and gone to that beneficiary. So important for making sure the beneficiary is very clear what they've received. The trustees are very clear what has happened, and the revenue know what's happened as well. Keep accounts. Very, very important to keep accounts, again, for revenues purposes, but also there are cases where if a trust isn't run properly, a third party, be it the DWP, HMRC, local authority for care fee purposes, they can look behind a trust and say it's not been managed properly. In reality, these assets actually belong to the individual. Come on, because you trustees have not been exercising your powers properly or appropriately. Question about 12-year-old son, 8-year-old daughter. Can one trust cover both? Yep, you'd probably want to do a discretionary trust in that case, so that when daughter reaches 18 or older age, the trustees can give her that half of the trust. Your disabled son, his half of the trust can be converted to a disabled person's interest trust. You get the tax advantages and the the asset protection as well. Conscious of time, so I'm going to rattle through some case studies in a second. All the information we talk about so far does relate to both will trusts and lifetime trusts. As I say, a will trust is basically just a trust that's set up under your will. There are certain tax differences, inheritance tax differences, between a lifetime and a will trust. But what a lifetime trust is, basically you just make a trust during your lifetime, and they are a useful planning tool. You make a trust, be it discretionary, life interest, whatever it might be. You put £10 in it, and it just sits there waiting. And it might receive your pension benefits when you die. It might receive your death in service benefits if you die while employed and you have a death in service through your employer. It might receive life insurance. It might receive gifts from other family members. And you may be saying, well, why would we want to do that? And the answer is pension benefits, death in service and life insurance and gifts from other family members don't necessarily pass through your will. And if those assets, you want those assets to go to your children in the future, you're going to have to make sure there is a separate lifetime trust to receive those assets in order to make sure you get all that protection, all the benefits I've talked about earlier. So you might end up with a will trust that's got your property and your savings and your investments sitting in that, and a lifetime trust that's got your pension benefits or your capital sum or death in service. Both trusts sitting there, same beneficiaries, same trustees even, managing it for the children in the future. So one of the key things to do when making your will, make sure you understand actually what you own and what you're entitled to, so you know that you're structuring your estate properly. And by doing it that way, as I say, again, it might avoid having a deputyship, because if you've made a pension nomination saying the capital sum passes to my wife, but if she's died before me, it passes to my children, bear in mind that capital sum would belong to the children. If one of them is incapable, you'd need to go off and get a deputyship. Whereas if you nominate the pension fund to a trust, you're not needing that deputyship. Is it better to appoint a solicitor as one of the trustees? Depends on the circumstances. If you've got family members who are get on well and are clued up, fine. You don't need a solicitor at all. You don't need a professional. If you think the family members might not get on, or they might need some hand-holding initially, yeah, appoint a solicitor, no problem at all. A solicitor alongside them. If you think, well, actually, there's no one in the family who really has a clue what to do, then maybe you want to appoint a solicitor or a professional to manage the trust. Question about would the trust impact and stop benefits? Let's have a look at this case study, and I'll answer that question there. So here we go. Here is, in the last sort of 5 minutes, a case study about Mr. and Mrs. Scratchit. I'm a Blackadder fan, in case you recognise that reference. Mr. Scratchit has a property of about £300,000 and savings of £250,000. So himself, he's got about £550,000. Mrs. Scratchit, she's only got £50,000 herself. He's the one who's done all the working during his life and everything like that, and she's been looking after the family. The house isn't in their joint names. It's only in his sole name there, and that's important for what I come on to. They've got 3 children, Tom, Bob and Alice. Tom's 16, Bob's 21, and Alice is 25. Tom's in education, and he's got special educational needs. Bob sadly suffered a brain injury and mentally incapable of managing his finances. Alice, on the other hand, very successful business owner. So there's our family. They don't make wills. Mr. and Mrs. Scratchit don't make wills. Bad idea. Sadly, they both fall very ill. Mr. Scratchit dies first, and his wife dies only 20 days later. Under the intestacy rules, a spouse must survive 28 days to inherit. In fact, any beneficiary under the intestacy rules must survive at least 28 days to inherit. So that means that Mr. Scratchit's assets do not pass through his wife's estate. They go straight down to the children, as indeed do Mrs. Scratchit's assets. That means on Mr. Scratchit's death, there's going to be inheritance tax, because he's got no chance to take advantage of Mrs. Scratchit's nil rate band. He's only got his own nil rate band, £425,000. His resident nil rate band, £175,000. There's tax on the £50,000 that exceeds that limit. That wouldn't have happened if they'd structured their wills properly. So the rest of the assets, in total about £190,000, pass to each of their children outright. So let's have a look at what happens. Well, first off, poor Tom. He's actually not too bad, especially education needs aren't too bad. By age 18, he can live independently and manage his finances, but he's young, doesn't see the benefit in property ownership, prefers renting with his friends. He's easily influenced and vulnerable to financial abuse, meets a girlfriend, they rent a property together, and she persuades Tom to buy all these lovely expensive gifts out of that £190,000 he received. Eventually he runs out of money, he has to move to state-funded accommodation, loses all faith in relationships, and ends up as a lonely bachelor after his girlfriend leaves him because his money's run out. What about Bob? Well, Bob needs full-time care. His health needs aren't sufficient to qualify for NHS CHC funding. He's got more than £23,250 now. He's received that £190,000 from the estate, so he gets no financial assistance whatsoever to his care needs. He also loses all means-tested benefits. He can't manage his finances. Alice is too busy with her business to properly act as deputy, so the local authority apply. So the local authority are now managing Bob's £190,000. Relatively swiftly, that money runs out paying for his care and providing him an income because he has no state benefits, means-tested state benefits anymore. So he finally ends up being completely reliant on the local authority to meet his care needs. And Alice, well, she was doing quite well, wasn't she? So she uses the money to pay off her mortgage, invest the balance. But before her parents had died, she actually took some time to look after them, which meant her business had suffered as a result. So she uses some of the money to prop it up. The business still fails, though, and she has to file for bankruptcy. That £190,000 she has to sell her property, settle her business debts, and she's left with very little money and goes off and seeks employment. It's a bit of a sad case there. So let's see what happens if Mr. and Mrs. Scratchit do make wills. So in this case, they decide to leave their estates to each other. There's no survivorship provision. They say, yep, you receive it immediately on my death. On the second death, it passes to a discretionary trust. That's the trust where no one has any right to the assets within the trust fund. You've got spouse exemption and you can claim both NORIC bans. So no inheritance tax. We've saved 20 grand straight away. Alice is one of the trustees along with a solicitor, and a letter of wishes, they leave letters of wishes with the will saying, please give a third of the fund to Tom when he's financially mature, keep a third of the fund in the trust to help Bob with his care, and give the remaining third to Alice outright if she wants it. So how do things change now? And hopefully this will answer a few of the questions that have come up during the day. Well, first thing is say Tom is able to live independently, still doesn't want a property, wants to rent with his friends. So the trust pays for his rent out of the income from the trust fund. Tom's girlfriend wants him to buy her nice gifts. The trustees say, no, we're not going to give you any capital to do that. She's a gold digger. We're not going to give you anything. We'll give you your income to pay for the rent, but that's it. So the girlfriend eventually leaves Tom because she realizes he's not a gold mine. And Tom meets Wendy and they have a lovely relationship and she helps him manage his finances. And then age 25, he's well settled. He's got a good relationship going. He's financially mature. He's not at risk. So the trustees go, great. We will give you, Tom, your £200,000 now. There it is. So he's now got that money outright. No need for his share of the trust to continue. In Bob's case, well, this time he doesn't own more than £23,000. That money has not come through the will outright to him. So he can ask the local authority for help for his care fees. He can keep his means-tested benefits. And the trustees can use the money to help him. They might buy him a property to live in. They might pay for some additional care and equipment. No deputy is needed to manage that money because it's being managed by the trustees. The local authorities basically don't get their hands on it. On Bob's death, the balance of that trust fund, his assets in the trust, are added to Tom and Alice's shares. So now Tom and Alice's shares have virtually doubled in value. And then Alice, well, what about Alice? So she's aware her business is in jeopardy. So she says to the trustee, look, please, could you give me some money to help prop it up? The trustee say, well, actually, we think it's a bit of a risky investment. If we do that, the business may still fail. We're going to keep the assets here. Sorry, Alice. She files for bankruptcy, still loses her house, but the assets in the trust aren't taken into account in that bankruptcy because they don't belong to Alice. Instead, the trust lends Alice some money. She starts a new business, which flourishes. She does very well, becomes wealthy, repays the loan to the trust and says, well, actually, I actually don't need this trust money. I've done really well for myself. Instead, she says, keep the money in the trust and use it to benefit my children. The advantage there, that money doesn't pass through her estate. It's not subject to inheritance tax in her estate. Very, very flexible way. And Bob, Tom and Alice have come out of it really quite well together. Hopefully, that's probably raised a load more questions, but hopefully it's given you a lot of information about trust. The key message there, good old Baden Powell, be prepared, do a will in advance, take advice on it, make sure you know what you own, make sure you can understand what happens after your death. and how you can structure your will to look after your children. As mentioned earlier, the slides, the video recording will be shared. I've just put a glossary of terms in there that you might come across when dealing with wills and estates and so forth, and trusts, and hope that's just useful by way of reference. There are my details. The awful picture of me there, I absolutely hate it, but you're more than welcome to drop me an email if you've got any additional questions. Say my specialism is everything we've been talking about today. Very happy to discuss. Big question there, how much to make wills and trusts approximately? I always get asked that. I'm trying to say it's a piece of string, really. It very much depends what you want to put on there, how much advice you get. Fees can range from between sort of £175 up to £1,200 plus. So it really depends on what you need. I think we've got a couple of minutes. Kate, do interrupt me if you need me to stop, but I was going to say there's a couple of questions that are popping up there that I'm very happy to answer if that's okay.
Do it. If you're happy to continue, we're happy to continue.
Lovely. Okay. They're popping up very quickly, so I shall pick them at random. What happens if I should need to go into residential care? Well, okay, your own assets, the things you own yourself, yes, can be taken into account for your care needs. If you're living, or in terms of your property, that means your house would be taken into account, unless a relative over the age of 60 or financially dependent on you is living in that property, or a spouse is living there, in which case the property would be disregarded from a financial assessment for care fees. One of the ways these trusts, the will trust structures, can help is if you own a property jointly with your spouse, rather than leaving the property outright to the surviving spouse, you put it into a trust. The survivor can carry on living in that property, but if they go into care, okay, yes, half the value of that house should be taken into account for care fees, but the other half that's sitting in trust is protected for the children in the future. Very, very common structure that we put in trust there. I would say you do find organisations out there saying, put your house into trust during your lifetime, that will protect you from care fees. Proceed with caution. The answer there really is, it might protect your house from care fees, but local authorities are so squeezed on their budgets that we do see a lot that they are challenging lifetime trusts where you give away your house, put it into a trust during your lifetime. The local authority are going to say, well, you only did that to avoid paying care fees. We are going to look behind that. We are going to treat you as still owning that asset anyway. It's called deliberate deprivation of capital. And we do see a lot of challenges to these trusts. And frankly, I think we're going to see a lot more in the future. So do be very, very cautious about signing up to any scheme to give your property away during your lifetime. 2 disabled children with different fathers, advice, different trustees, etc. Yeah, I mean, maybe. It very much depends on the circumstances. You can have one. There's no reason you can't have one trust with the 2 children as beneficiaries. I think it's worth thinking about what assets are the different children going to receive from their different families. Would one do better than the other? Maybe. In which case, you might want to have 2 separate trusts, one with slightly more in it, one with one separated out with slightly less. Different trustees, yeah, again, maybe. It really depends on the circumstances and the situation of the different dads. You certainly could have the dads as trustees of the different trusts, along with someone else. I think would be very sensible to have there. Potentially, you might want a sort of mutual individual trustee, so one dad on one dad on the other, and then one person is a trustee of both. That way they can sort of talk, they understand what's happening between those different trusts, but really depends on the circumstances. Julia, so if you have 2 sons and want to leave your property house to one, are you not allowed to do that and avoid inheritance tax, etc.? Okay, struggling slightly with that question, but well, I'd come back to the point that don't do it during your lifetime. Don't give your house away outright to children during your lifetime. That's not going to work to save inheritance tax, and it's not going to work for asset protection for care fees purposes. No reason why under your will you can't leave one son the house outright. Although actually, what's the other son going to say about that? Is there a reason to treat them differently? It won't make any difference from inheritance tax purposes if you favour one son over another. But I'd kind of come back to that point of, if your joint estate between husband and wife is not worth more than £1 million, or if you're single, the estate's not worth more than 500,000 and you own a property, don't worry too much about doing inheritance tax planning. Just look at the structure of the will, make sure it's working for your children in the future. Oh, Darren, yes, your question about money received for the son, be it birthday, Christmas, etc. Where should we put it? Yeah, really good question there, really good question. If you put it into an account that is his, so that nominee account that I talked about earlier, the one which you are on the title, but he is the one who has the money out right underneath, then yeah, any money in that account is his at the age of 18, which means that if he lacks capacity or is vulnerable, you're looking at a deputyship, attorneyship, or possibly the risk of him spending that money. So I'd say if it's going to be substantial sums of money that you don't want him to have access at age 18, think about setting up a lifetime trust, that idea where you have a trust that holds £10 ready to receive birthday presents, Christmas presents, pension fund, money from other sources. You can put that in a lifetime trust. He doesn't have access to it immediately at 18, and you don't need a deputy or attorney to manage that. The one thing I would say though is, because of the administrative hassle and the cost potentially of running trusts, really the sort of the minimum value you want in a lifetime trust is probably 40,000 pounds, something like that. I mean, you don't, it's not compulsory you have more that amount, but just thinking about the administrative hassle of running it, that's the sort of figure that you should be looking at. What else? Can you set up a life interest trust until they turn a certain age? Can you choose the age? Yes, absolutely you can. So again, under your will, you can say, look, up until age 25, 30, 40, whatever you put in the will, the beneficiary is only entitled to income. At that age, they receive the capital.